Well, thank you all for coming and welcome to the Heritage Foundation. You're in for a treat this afternoon. We have three excellent Supreme Court watchers to discuss what we saw yesterday at the Supreme Court with oral arguments. The fact of the matter is that yesterday's oral arguments were excellent. There were so many good points made about what marriage is and why redefining marriage could cause harms. And the litany of harms that were pointed out stands in stark contrast to the outrageous lower court ruling that had declared no rational basis to state laws defining marriage as it had always been throughout American history, the union of husband and wife. Most importantly, it was clear that the 9 Supreme Court justices do not have any greater insight into ideal marriage policy than do ordinary citizens, and that the Constitution itself is silent about what marriage is, so justices should uphold the authority of citizens and their elected representatives to make marriage policy in the states. Joining us today to expound on what they heard at the court are Jean Scher, Jim Campbell, and Carrie Severino. Let me just say a brief word by introduction of the three, and then we'll turn it over. They'll each say about 5 to 10 minutes of opening reflections. I'll ask them some questions, or we might just go straight to your questions. We want to hear what you're interested in learning about oral arguments. Jean Scher is a Washington, D.C.-based attorney who specializes in constitutional and appellate litigation. He has previously served as associate counsel to the president and as a law clerk to Justice Antonin Scalia. Jean has handled dozens of cases, including 6 that he personally argued before the U.S. Supreme Court. Jim Campbell serves as the director of the Center for Marriage and Family with the Alliance Defending Freedom in its headquarters in Scottsdale, Arizona. He specializes in litigating cases pertaining to the defense of marriage, religious liberty, and freedom of conscience. He earned his J.D. from the University of Akron School of Law, and he's admitted to the bar in the states of Ohio and Arizona, along with the federal bars, including the Northern District of Ohio, U.S. Courts of Appeal for the 6th, 9th, and 11th Circuits. Carrie Severino is Chief Counsel and Policy Director of the Judicial Crisis Network. She served as a law clerk to U.S. Supreme Court Justice Thomas and to Judge David Sentel on the U.S. Court of Appeals for the D.C. Circuit. She's a graduate of Harvard Law School and of Duke University, and she holds a master's degree in linguistics from Michigan State University. Please join me in welcoming the panel.
Well, for me, the most frustrating part of the argument yesterday, and I was seated fairly near the front of the courtroom, but the most frustrating part of the argument was the initial comment from Justice Kennedy, who everybody expects to be the deciding vote in the case. And I heard Justice Kennedy say, after a little bit of wind-up, he says, you know, as I've thought about this, the most important word for me in this case is blah, 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 blah. And his voice kind of trailed off, and I couldn't hear what the key word was. But then he repeated it, and he said the most important word in this case for me is millennia. The point being that this definition of marriage as being the union of a man and a woman has been around for millennia. And then he proceeded to ask the rhetorical question of the petitioner's lawyer, the lawyer seeking to have the court redefine marriage nationwide. You know, he said to her, look, this definition of marriage, the man-woman definition of marriage, has really been around for millennia. There are people who think that changing the definition of marriage could create risks or problems, and who are we to tell them they're wrong? Now that comment out of the box I thought was very significant because, as most of you probably know, all of the pundits out there have been saying for a long, long time, oh, Justice Kennedy has already made up his mind. You know, this case is already decided. Justice Kennedy is just waiting for the opportunity to pull the trigger, as some people have said, and impose same-sex marriage on the nation. Well, his argument, his comments out of the box were not the comments of somebody who's just waiting to pull the trigger on same-sex marriage. That's no guarantee that he's not going to end up voting to do that. But they were clearly not the comments of somebody who's made that decision already, or at least who had made that decision as at the beginning of the argument yesterday. And I'm not going to try to predict the outcome here, but I think Justice Kennedy's initial comment reflects the first of three major themes that I'd just like to briefly put on the table that I think emerged from the argument. Number one, as Justice Kennedy's point made clear, societies have long defined marriage as a union of a man and a woman for reasons that have nothing whatever to do with homosexuality. Justice Kennedy himself mentioned how the man-woman definition of marriage has arisen in virtually all primitive societies, regardless of their views of homosexuality. And then Justice Alito followed up on that point and pointed out how in ancient Greece, which was a society that was pretty open and accepting of homosexual relationships, the ancient Greeks still insisted that marriage had to be limited to a man and a woman. Plato extolled same-sex sexual relationships, but still insisted that marriage had to be limited to a union of a man and a woman. And then the counsel for Michigan, John Birch, who I thought did a very good job, he made the point that in fact marriage exists principally to connect a man and a woman to their biological children for the sake of their children. It's not intended to disparage gays and lesbians, and it's just a recognition of a fundamental biological fact, which is that men and women are the only kinds of romantic pairings that have the ability to create children together, and sometimes accidentally. And so it's important that society have an institution that is designed to deal with that unique, I won't say problem, but that unique situation. And the Chief Justice's first question really emphasized this point as well. He said that the Petitioner's Counsel began by saying, we just want to join this institution of marriage. And the Chief Justice said, no, wait a minute, you can't really say you're just asking to join an existing institution. What you're really asking for, what you have to have in order to be able to be married, is you have to have the institution redefined. And that's not just joining it. So you're really trying to have the court impose a different meaning on the institution of marriage than what it's had for millennia, to go back to Justice Kennedy's term. The second main theme that I think emerged from the argument is really the most important, and that is, regardless what one thinks about the reasons that most states have decided to preserve the man-woman definition of marriage, regardless of what one thinks of those reasons, the real issue here in this case is who decides. And Justice Scalia, of course, made that point early on. He said the issue here isn't whether there should be same-sex marriage, but who should decide the point. And even Justice Ginsburg, who I think most people believe will ultimately vote to impose same-sex marriage on the nation, she began with a question, and really the very first question by any justice was to the Petitioner's Counsel. She said, what do you make of Windsor, which was an earlier decision 2 years ago involving the Defense of Marriage Act? Justice Ginsburg asked, what do you make of Windsor, in which the court stressed the federal government's historic deference to states when it comes to domestic relations? And Petitioner's Counsel, I thought, did not have a very compelling answer to that question from one of the justices who most people think will be one of her allies. And then Justice Breyer, a little bit later on, made this comment. He said, the law everywhere for thousands of years among people who were not discriminating even against gay people was the man-woman definition. And suddenly, he said, you want 9 people outside the ballot box to require states that don't want to change what they're doing on marriage? And then he said, why can't these states at least wait and see whether, in fact, doing so in other states is or is not harmful to marriage? And once again, I didn't think the Petitioner's Counsel had a very effective answer to that very telling question. The third main theme is kind of reiterates a point that Ryan and I have been making for some time together now, which is that the plaintiff's claims in these cases are really a policy argument in search of a constitutional theory. When you get right down to it, there really is no plausible constitutional argument for imposing same-sex marriage on unwilling states. You know, and that's shown by a number of things that happened during the argument yesterday. First of all, the petitioner's counsel could not give a clear answer to that question when Justice Breyer, who again most people think is likely to be friendly to her side, he asked her a very pointed question. He pointed out, you know, you've kind of dodged and evaded this question 3 or 4 times now. I want a clear answer to it. What, in fact, is the constitutional basis for telling unwilling states you have to redefine marriage to include all consenting adults rather than sticking with the traditional man-woman definition? And even after he pressed her, she didn't really have a very good response. You know, it was sort of vague arguments about dignity and how, you know, how our children will be viewed less favorably if we don't have marriage and those sorts of things. So it really was her answers made clear that her argument really was a policy argument or a policy plea in search of a constitutional hook. And then, of course, we had the United States Solicitor General who argued in support of the petitioner's position, but he only advanced one argument, which is, I think, the argument that the court is least likely to adopt, which is that sexual orientation should be treated as a suspect class, and therefore, in his view, anything that even has a disparate impact on gays and lesbians ought to be subject to the highest form of constitutional scrutiny. Now, he didn't really articulate the argument quite that way yesterday, but that is really the argument that the United States has made in their briefs. So, you know, and then when he was asked if he supported the other main theory that the petitioners have been pressing, which is the idea that there's a fundamental right to marry anybody you want, essentially, you know, he disclaimed reliance on that and said no, the United States was going to stick to this, you know, to this broader, more sweeping theory of a suspect class. And then later on in the argument, Justice Breyer came around to suggesting that he thought maybe the fundamental rights theory was the most persuasive, but then Justice Kennedy came in and pointed out how to adopt that theory and apply it to same-sex marriage would be flatly inconsistent with the court's existing precedents on how you determine what is and is not a fundamental theory. So I think at the end of the day, it's not entirely clear how the court is going to decide this, but my own view is that you know, the positive signals for the pro-traditional marriage side were probably outweighed any negative signals that the other side could point to. And again, that doesn't guarantee that that we're going to win, but that was my bottom line conclusion.
Right. Thanks, Gene. I agree with a lot of your analysis. I'll add a couple different points. I think after yesterday's argument, I'm feeling a little more optimistic than I was going into it, but that still leaves us sort of an equipoise. And I think the major themes, of course, Kennedy is still likely the swing vote in this case. The major themes I see are really, for him, is marriage the institution that we view as a conferring dignity on people, and that this is a mean-hearted way to deny individuals' dignity, or is this an institution that, as he said, has endured for millennia, predates governments. That was an interesting point that Kennedy brought up, that this is not even talking about governments, but we have pre-governmental societies. Certainly there are marriages that predated our Constitution. And that includes non-prejudicial societies, so societies that are very happy to accept homosexual relationships but don't consider them the same kind of thing as marriage, as we actually saw, for example, in France when there were major pro-marriage rallies a few years ago, not because they're opposed to homosexuality, but because they believe this is something very different than we're talking about in marriage. And then also the theme of, do we trust the American voters? And on that line, there was actually an interesting case that was decided today, a different topic. It's a First Amendment case in the context of campaign finance regulations in judicial elections, but I liked one line in it in Justice Kennedy's dissent in that case, because the majority opinion upheld the restrictions on the campaign finances, but he said, it's not within our nation's First Amendment tradition to abridge speech simply because the government believes a question's too difficult or too profound for voters. And that kind of echoes some themes that he brought up last term in the Schuette case, dealing with another Michigan law that was upheld, mandating colorblind treatment of across the state law, and also saying, you know what, we have to trust the citizens sometimes, even on really contentious issues where there are good minded people on both sides, that they're going to be able to work this through in a democratic system. And so I see that as maybe a glimmer of hope that this trust of the democratic process and trust of the American people may shine through here. I think another interesting parallel to look at is Justice Kennedy's abortion jurisprudence, actually. He's certainly someone who's very protective of the constitutional right to choose, whatever the rest of us may think of the existence of such a right. He believes in that and wants to defend that, but he also realizes that he has limits on that. So we looked at the Gonzalez versus Carhart decision where with partial birth abortion, he said, you know what, there are certain distances to which he won't go, and there are certain limitations and regulations of abortion that Justice Kennedy has upheld. And so one wonders whether this might be his Gonzalez versus Carhart case in the context of his series of cases talking about homosexual the treatment of homosexuals by law. We have the Romer decision saying that we can't have a state law that has a specific, that specifically targets a group like homosexuals. We have his Lawrence decision saying you can't criminally penalize this behavior, and Chief Justice Rehnquist brought out this distinction, I believe, in yesterday's arguments. That's a difference between now taking the next step and saying a state has to subsidize this relationship. It's one thing to say you can't penalize it, and it's an additional big step to say you have to subsidize it. So this may be, even for a justice that has a definite pattern in his case law in this area, this could signal the distinction between where he's going to go. And then one other, I think, interesting theme that was brought out by several different justices was what the implications are, potential implications are of this case for religious liberty. And that was brought up in one case by Justice Scalia. He was asking, is it possible then to force, he asked if it was possible to force religious ministers to perform these ceremonies. I think that's less of a risk. I think what's more likely is that religious ministers might be deprived of their ability to actually perform state-sanctioned marriages. So rather than having your priest or your rabbi stand up there and say, by the power vested in me in the state of Virginia or whatever, or the Commonwealth of Virginia, you're going to have them say, just marry you according to your religious tradition, and then have to perhaps go to the courthouse and get your own marriage by a state official. And also a very interesting answer that the petitioner's lawyer gave when in follow-ups to that was that she conceded that if you are, say, a justice of the peace, where part of your job is to perform such ceremonies, it seems very likely that if the court decides this case in favor of the petitioners, that you won't be able to say, I have a personal religious objection, I don't want to perform these marriages, can you go next door to the other judge who's on duty or whatever. You wouldn't be able to have those jobs. So it's religious objectors need not apply to some of these official positions that might actually involve consummating or celebrating marriages as part of your job. Also, Justice Alito brought up the Bob Jones case, which allowed a university to be deprived of its tax-exempt status, and asked, is this something that could happen if we decide that we have to, that there's a fundamental right to these relationships, is going to be such an important federal public policy that now you can't have a tax-exempt status as a religious institution if you oppose the new orthodoxy on this view. And there was actually a very chilling, I thought, response by Solicitor General Verrilli, where he kind of dodged the question and then said, well, but that is seriously going to be an issue. So the administration clearly wants to preserve the ability to remove tax-exempt status from institutions like a religious university, but it wouldn't be just colleges. I don't think there's any reason to say it clearly wouldn't extend to charitable organizations, et cetera, potentially even to removing tax-exempt status from a house of worship. It's a different, slightly different argument, but I can certainly see people trying to make that argument. And so I think that ought to really give a lot of people pause of, wow, this is a absolute head-on collision potentially with religious liberty, because the arguments that are being made on the other side are so extreme here. So the final example it was also made in that similar context. Would a religious university be required to extend its married housing to a same-sex married couple, even if that religious university is opposed to same-sex marriage? And I think that clearly would fall under this case. That they didn't choose to answer very directly. The Solicitor General said, well, depends on the state law, maybe there's no federal law right now, but the bottom line is, absolutely. If there was a state law that decided to cast that balance that way, absolutely, and as soon as there's a federal law requiring putting sexual orientation on the same level as we have in civil rights law with race and gender, which I think is certainly part of the agenda that's going on, that is going to be an issue as well. So I think those potential collisions were brought out and potentially will affect the way the justices decide this case, because I don't think, hopefully none of the justices, but I think certainly Justice Kennedy is not going to want to have that kind of a collision with religious liberty. And I think Chief Justice Roberts, any of them ought to be concerned about the potential for further limiting religious liberty at this point. And so perhaps even if it doesn't mean that that's going to affect the outcome entirely, doesn't mean they're going to say, well, in that case, we're going to let the states decide what they want. It may affect the way that the opinion at least is written in a way that has less of a risk to completely steamroll the remaining religious freedom that we enjoy. So.
Well, I think everyone hit the high point so far. Religious liberty was one thing that stood out to me. Also, the desire not to take this issue away from the people and some of the concerns with doing so. And I think Gene touched on that. So I'll try to touch on a few remaining points that haven't been hit already, but I will say that these are more ancillary to what has already been discussed. First thing I would say is reading the tea leaves on Kennedy, which I think Carrie did a pretty good job of, and I think that's what everyone's thinking about right now. The one point that hasn't come out so far is specifically his quote on dignity from yesterday, and that is, he said John Birch was making an argument about in defense of the laws, and he said something like, the state doesn't recognize marriage to confer dignity. And he was making a point. And he was interrupted by Justice Kennedy. And Justice Kennedy said, I'm confused by your point. He said, I thought the whole purpose of marriage, I thought that was the whole purpose of marriage. So that was, on the one hand, what raises the concern about Kennedy being one that is going to view this through a dignity lens, which I think is what Carrie was touching on. But on the other hand, I think Gene highlighted very well some of the positive things that Kennedy said. Kennedy seemed very concerned in some sense with changing an institution that has been around for millennia. So I think that is going to be the struggle, and I was most worried with Kennedy's comment about dignity and saying that I thought that was the whole point of marriage. But having said that, there was some encouraging stuff, probably more encouraging stuff in the end that came out of Kennedy's mouth yesterday, which I think is a good thing. One other thing that Kennedy said, which I think is worth highlighting, is he was engaging with counsel for the petitioners, and so the counsel arguing in favor of same-sex marriage, and he said something like, you can't have it both ways on the social science. If we're going to do this now, then then it seems to me unfair to look at the social science. And I think I maybe have that quote here. He said, you say we don't need to wait for change. So it seems to me that if we're not going to wait, then it's only fair for us to say, well, we're not going to consult social science. And his point was the social science is so new. So I think, again, that reinforces what we've been talking about, which is in Kennedy's mind, this really is going to come down to dignity versus changing an institution that has been around forever. And I don't know that he's going to be inclined to wade into the social science, given what he said there. One other point worth highlighting is the concern on the impact that this would have on democracy more broadly. And I think that's well illustrated by what Chief Justice Roberts said when he was talking about the issue, taking this issue away from the people. He said something along the lines of, if we impose same-sex marriage nationwide through a judicial decision, that will close the debate, and closing the debate can close minds, and it will have consequences on how this new institution is accepted. People feel very differently about something if they have had a chance to vote on it than if it's imposed on them by courts. And I thought that was really well said, and it's certainly a theme that Michigan emphasized in their brief, as well as some of the other respondent states. Lastly, I'll just touch a little bit on the recognition point, which is the second question, and that is, assuming states have the authority to license marriages within their borders as they see fit. So if they only want to solemnize marriages between a man and a woman, where does that leave us on the recognition question? So could they decline to solemnize same-sex marriages in state, but yet have to recognize those formed out of state? And on the broad question, I think Chief Justice Roberts really hit the nail on the head when he said that the implications of adopting that argument would be that, what exactly did he say? It was something like one state can make the marriage policy of the nation. And that really is the bottom line on that argument, because we're such a mobile society, and that's what Chief Justice Roberts said, that people can just go to another state, get a marriage license, come back. So you would be indirectly redefining marriage in that state should you adopt that argument. I went through the transcript this morning, seeing if I could pick up anything from Justice Kennedy on the second issue, this recognition question. And he only asked one question. I scanned it quickly, so I might have missed one. But he said to petitioner's counsel, so the counsel arguing in favor of the position that the Constitution requires out-of-state same-sex marriages to be recognized. And he said, if we get to this question, we've already found that the state has a sufficiently important interest to allow them to affirm man-woman marriage in their state. And he said, so we have to adopt that presumption. And he said, so suddenly, now if you're out of state, it's different, and why should the states all of a sudden have to yield? And I took that to be an encouraging sign, given that was the only thing he said. It was a question to petitioner's counsel. Now, I don't know that we could read much into it, but he certainly, I found it odd that he wasn't asking many questions of the state's attorney on the recognition issue. The only other point that I would bring out on the recognition issue is something that I think Justice Alito pointed out in a few lines of questions that it was interesting to me. I don't know how interesting it will be to you all, but I think there are some lessons to maybe glean from it. And that is, he said, what other marriages have states declined to recognize? And one of the points was, well, they've declined to recognize underage marriages. And his response to that was, right now we're talking about the difference between man-woman marriage and same-sex marriage. And he said, that's a significant policy shift. And he said, what's the next closest significant policy shift? And the response from petitioner's counsel was underage marriages. And then Alito quickly pointed out that, didn't you previously concede that a state could decline to recognize an out-of-state underage marriage if the age was roughly 14 or so? I don't remember the exact number he used. But I thought that was an interesting concession when you line them up. The other thing that is maybe more interesting than that is that Windsor expressly recognized that the states differ in their marriage policy, and it implicitly authorized such differences, and one of the differences that it pointed to was underage marriages. So reading between the lines there and trying to draw something from it, I tend to think that the court is unlikely to find that states can define marriage in state for their own purposes, yet have to recognize an out-of-state same-sex marriage that conflicts with its own public policy. Having said that, it might be the middle-of-the-road approach that the court decides to adopt.
Great, thank you. Let me say one thing to summarize what I think were the kind of three main points that we just heard, and then I'm going to open it up to your questions and invite the panel to give you answers. It struck me that the three panelists gave us three different types of harms that a judicial activist decision on this question would cause to our nation. Harms to the institution of marriage itself. This was Kennedy saying that we don't yet even know the social science on these new parenting forms. Why can't we wait and see? This was Justice Breyer saying, why cannot the states that want to retain the man-woman definition of marriage wait to see if the other states that have redefined marriage, see if it's harmful or not? If the court were to redefine marriage for the entire nation once and for all this coming June, we won't be able to see whether or not redefining marriage causes harm to the institution of marriage. So one type of harm, if the court takes this out of the democratic process, is harm to marriage itself. The second type of harm is harm to the democratic process itself, harm to the civil peace. This is what Jim mentioned by quoting Chief Justice Roberts. Roberts said that if we, the court, rule on this, quote, there will be no more debate. Quote, closing of debate can close minds, and it will have a consequence on how this new institution is accepted. People feel very differently about something if they've had a chance to vote on it than if it's imposed on them by the courts. So there's a process harm as well. If the courts redefine marriage for all 50 states, it'll harm democratic self-government and civil peace in the wake. And then lastly, the harm to religious liberty. And this was both the quote from Alito and from Scalia, that if the court redefines marriage, what will be the status of those Orthodox Jews, Roman Catholics, evangelical Protestants, Latter-day Saints who continue to believe marriage is the union of a man and a woman and want the freedom to run their institutions in accordance with that belief without government penalty? Will they lose their nonprofit status? And the Solicitor General said that's going to be an issue. I'm not going to deny it. It'll be an issue. Scalia immediately pounced when he was asking his line of questioning. He said that in the states, this hasn't been as much of a problem. And he goes, they are laws. They are not constitutional requirements. That's the whole point of my question. If you let the states do it, you can make an exception. You can't do that once it's a constitutional prescription. Scalia's point was that if you let this resolve democratically, we can protect the right to dissent. We can protect religious liberty through the democratic process. But if you get the court to redefine marriage, it'll be much harder to do that. So those just strike me as three of the constitutional harms that would come if the court were to resolve this. And it's not surprising that we've seen exactly those three harms the last time the court tried to solve a policy matter like this in their Roe v. Wade decision. We've seen substantive harms to women and children when the court took the abortion issue out of the democratic process. Just look to Kermit Gosnell's abortion clinic to see what happens when we can't make abortion policy democratically. We've seen harms to civil peace and democratic self-government. Look at the culture war that the Supreme Court created after the Roe v. Wade decision. Like Robert said, you close minds. You don't allow the people to feel that they've had a voice in abortion politics. And then lastly, we've seen consequences for religious liberty because of the court's ruling. And most recently, just look at the HHS mandate through the Obama administration. So why would the court want to repeat precisely those three harms on this new issue when allowing it to work democratically could avoid those harms? So that's kind of my summation. And now we're going to open it up to the floor. We have microphones, so just raise your hand. I'll call on people, wait for the microphone, and then we'll try to provide answers. Floor is open. Yep.
Thank you. It just makes one wonder then why the court denied cert last year in the cases arising out of the 4th, the 7th, and the 10th circuits, and what would the implication be if the court were to rule in favor of upholding the 6th Circuit decision? What would then happen in all of those states that have had judicially imposed redefinition?
I'll take a crack at that. One of those decisions you mentioned is one that's near and dear to my heart, and still a source of pain that the court denied the Utah case back in October. But it's not that unusual for the court just to decide not to take up a difficult issue because they're not ready to. And obviously there were people within the court and more than a majority of the court that felt like the time just wasn't right. And the advantage of waiting for the Sixth Circuit opinion is that then there really was a clear circuit split on the question post Windsor after the DOMA decision from 2 years ago, and so then I think pretty much all the justices felt like we really have to take this up now when the circuits are going different ways in their interpretation of our decision in Windsor. Prior to that, they weren't conflicting in their interpretation of the Windsor decision. As to your second question about what will happen in these other states, it'll really be up to the governors and the attorneys general of those other states to decide how to proceed. Once assuming the Supreme Court rules and affirms the Sixth Circuit decision and thereby upholds the marriage laws of Michigan and the other states, as a matter of law, the court will have established that yes, states do indeed have the right to maintain the traditional definition of marriage if they want to. So the question is, how do they go about getting out from under the rulings that have been issued before? And there are various ways that they could do that. One way would be for the governor just to direct people in the state, look, we've had a decision from the Supreme Court that establishes that our law is valid, and so from this point forward, we're going to go back to respecting the law that the people or their representatives adopted, and then wait for the other side to sue them if they want. Another option would be for the Attorney General in a state to go back into the district court that ruled against the traditional marriage law and ask that district court make a motion for relief from judgment and ask the district court just to vacate his or her prior opinion in light of the Supreme Court's more recent ruling. And then if the district court denies that motion, which they shouldn't, I mean that's a motion that any district court should grant, but if for some reason they deny that motion, then that denial can then be appealed up through the system, and then ultimately the Supreme Court, if it has to, can fix it.
One other observation to throw into the mix on the stays is what we saw yesterday is, at least what I saw, is that Kennedy's still struggling with this issue. And if everyone else on the court thought that Kennedy was struggling with this issue, everyone might have decided, we don't want to grant cert. The four more conservative justices might have thought, well, we don't know how he's going to rule on this, so we don't really want to bring it up unless we have to. The four more liberal justices might have had similar thoughts. So at the end of the day, they might have really been thinking, until we have to decide this, we're not sure how this is going to go, so we're not going to rush into this. And then once the Sixth Circuit created the circuit split, at that point they had to take it. So that's another way to read it.
Other questions? Yep, right in the middle. Coming from this way.
We're always so encouraged when we hear people like you make your explanations for, why judges might rule the way they should. In the end, they might, some of them will go by rule of law, and this is the way it should be. Others will rule, oh, I don't think that's a good thing anymore. We should change it. That's what we maybe think in this crowd. But what can you do when a judge doesn't rule by the law? And it seems obvious to everyone that they're going by their current personal opinion.
I mean, this unfortunately is what part of the harm to our judicial system when given some of the theories of constitutional interpretation, for example, where this sort of evolving constitution that we've seen and things like that, where it allows judges, in some cases, gives them a fig leaf for coming up with what their own policy preferences would be and substituting that for the law. I think ultimately, our best response, at least in the federal system where we have judges with life tenure, actually is to pay very close attention to how those judges get there. I'm someone who follows judicial nominations very closely, and I think realizing that when you're electing a president, when you're electing your senators, you are electing the people who are going to be putting these people on the court. And it's not a quick fix because, again, these are all individuals with life tenure, but we need to be very aware that that's actually one of the most important things, in my opinion, that a president does is nominate judges, because the laws they sign may be overturned by a future court, may be revoked tomorrow. The executive orders they do could be undone in 4 years very easily, but the judges they put on the court are there for the rest of that judge's life term. And unfortunately, we have a system which judges often, I think, do substitute their own positions for the Constitution itself. If we knew that everyone of whatever political preference they are is going to still follow a very strict method of constitutional interpretation, then it wouldn't even matter, I think, hopefully, whether a Democrat or Republican appointed them. You should end up with people who are going to come to very similar results in most cases. Obviously, there are very close cases that judges with similar interpretation can differ on, but I think we wouldn't be in the same situation we are now, where even every judicial nomination turns into a big political circus because we have all these litmus tests and stuff. It's because people are afraid that judges are going to substitute their views for those that are established in law and those that are enshrined in the Constitution. So I think we all need to remember that as whenever we're going to the polls and whenever we're talking with our elected officials, to that their decisions in the judiciary have serious consequences.
We'll go over here.
My question is in regards to what happens if the court decides not to find that there's a fundamental right. There's been questions about the chaotic policy implications and the states that would occur as a result of that. So I was just wondering what you guys, if you have an opinion of that, whether you think it would be as chaotic as some law professors say that it would be, or if you think it would be fine, et cetera.
I think the chaos argument is vastly overblown. There are a wide range of issues on which states have different policies. States have different tax policies. As Windsor pointed out, states have different rules about when people can marry even, and all of that. And it's a lot of states, I suspect, will decide voluntarily to recognize out-of-state same-sex marriages, even if they haven't done so yet. I mean, that's one potential political compromise to resolve that issue. And in fact, I'm not sure it's a huge problem if a couple is married in one state and then they move to another state and that state doesn't recognize their marriage. I'm not sure that as a practical matter it really makes all that much difference. I mean, we have a lot of people who cohabit without being married, and they are able to raise children and parent them and go to PTA meetings and all those sorts of things without without enormous inconvenience in their lives. So I'm just not persuaded that the possibility of different marriage regimes in the various states is going to be all that big a problem. I mean, we've had that. We've lived with that for quite a few years, right? We had Massachusetts adopted same-sex marriage in 2003, 2004, and and until just about a year ago, we had a situation where same-sex couples could be married in some states, but not in others, and there's no indication that created enormous practical problems.
Yep, over here.
First, I want to thank you because you've imparted more buoyancy to me today than I had yesterday. Though I could imagine, though, every argument that we've thrown back at us at these things we've heard, the best arguments we've heard today. Conservatives invoke tradition when they don't give a moral defense of their policy, and so you could see people say, "Well, slavery was around here for millennia before we decided it was wrong in principle," and that's how they would go. But I want to press Gene on this matter of what happens if they do sustain marriage. Because our understanding in the past over Roe versus Wade was that if Roe were overruled, those laws on the books in the states are still there. The court cannot erase those laws on the books.
Right.
Now, if we have states that have passed constitutional amendments and have laws, they are still there. So I think there should be no need to reenact them. So
I agree, and I didn't mean to suggest that they need to reenact them.
No, I don't think you did, but I wonder what's getting in the way here? Could we possibly face a Democratic governor who insists that no, he will not approve this sort of thing? Are there possibilities for obstruction here?
Oh, sure.
That would make us do the whole thing again?
Sure, yes, there are.
But I would highlight that
Elections have consequences.
there is one.
That's an interesting notion.
There's one way around it that Gene talked about before, and that is if you, say for instance, you had a governor or someone who wasn't going to call for everyone to recognize the law that was enacted, you could still try to get someone to file a motion with the district court that put the injunction in place. The injunction that now would be clearly inconsistent with Supreme Court precedent. So there are a couple avenues. It's not like the people in the state are confined only to can they convince their governor to do the right thing. They can also find someone who has standing to go into court and get that injunction removed.
Like a clerk of court or somebody like that.
In the Ohio case, they had some clerks of court who were asked to solemnize a marriage that was the same-sex marriage. It wasn't. They said, "I have a duty to obey the law, and here's what the law says in Ohio."
Right. Yeah, that would be an option too.
We'll go to Doug.
Last year, my son's boss at the time was married to her same-sex partner, and the person who performed the ceremony was Justice Ginsburg. I've read in the last couple of days that there's a move to get her to recuse herself. Is there any basis for that? Might that happen, or is that just a pipe dream?
Well, beyond doing that, I think the other basis for it that's been suggested is that there's some comments that she made subsequently in talking to the press, talking about how this is the nation's ready for this, et cetera. I think she clearly isn't recusing herself, so
she wouldn't have shown up yesterday.
Yeah, she wouldn't have been sitting there, and the likelihood that she was going to recuse herself was low, and even lower now that she's heard arguments. So,
Brian,
this is a Justice Kennedy question. I'm confused about something. In the last set of marriage cases, it was sort of my understanding. I think a lot of people thought that Kennedy said that the basis of marriage laws, again, having no same-sex marriage, was animus. In this set, he says, well, marriage has existed for millennia. And those two things seem completely inconsistent. The last time he said this was animus, and now he's saying that there's a long precedence for it, and presumably a reason why it is that way.
Yeah, and I think that's a very common but incorrect view of what he ruled 2 years ago in the Windsor case. In fact, he ruled in the Windsor case that states have the authority to determine their own marriage policies. And in that case, New York had decided first to recognize same-sex couples and then to license same-sex marriages. But in Justice Kennedy's view, the Federal Defense of Marriage Act improperly interfered with the state of New York's ability to set its own marriage policy. And one of the rationales Justice Kennedy used for striking down DOMA was that DOMA, at least the portion of it that was at issue there, had been based in his view on animus against gays and lesbians. But again, it was the use of animus in the service of upholding a state law that he viewed as being under attack from the federal government.
And I think another way of saying that is, to the extent it's helpful, is that Windsor found that the Defense of Marriage Act had animus. It didn't find that the institution of marriage as it has existed for millennia was motivated by animus. So if that distinction's helpful, I think that's another way to look at it.
Following up on that, there was an exchange between Kennedy and Verrilli, which I didn't fully get, and I'll quote it. Page 30. Verrilli says, thousands and thousands of people are going to live out their lives and go to their deaths without their states ever recognizing the equal dignity of their relationships. And then Kennedy responds, well, you could have said the same thing 10 years ago or so when we had Lawrence. Haven't we learned a tremendous amount since Lawrence, just in the last 10 years? What do you make of that exchange?
I mean, one reading of it is that he was having second thoughts about Lawrence, right?
Lawrence, I think the court was clear that it wasn't requiring same-sex marriage. So I think, and I'd have to go back and look at the arguments. My assumption is the government may have said at the time, oh no, this wouldn't require a change in marriage law. This is just saying we're going to decriminalize homosexual activity. And so it may have been Kennedy calling them on the carpet for changing their position on that at one point, saying, oh no, the arguments we're making here don't entail all of these huge societal changes, and now saying, oh, in fact, they obviously point to that. I'd have to go back and look at the transcript on Lawrence to know whether that's the case, but that was my read at the time of what he was saying.
Looks like we have time for one more question. Yep, all the way in the back corner.
Thanks. Just a couple quick questions. On the animus and the domo point, I recognize the animus wouldn't apply maybe for Kennedy as it relates to the institution of marriage, but could the animus argument apply to the laws the states have passed, constitutional amendments, specifically defining marriage to be man and a woman? So then the animus would apply in that context, just like it might apply within the domo context. And then the second point, or second question was, I think Justice Roberts brought up the argument that this is not, could this be seen as a issue of sex discrimination, not discrimination based on sexual orientation? And I'd like to see what your thoughts were on that kind of exchange and also the question generally. Thanks.
Well, I'll take a stab at the animus one. Animus, there are huge problems with equating animus to what's in the mind of voters. And the Sixth Circuit talked about this in its decision, and I think it's right. And if you look at the Supreme Court's doctrine on animus, it's never really purported to probe into the personal thoughts of legislators, or in this case, millions of voters. So what does animus mean then? There's a judge on the 10th Circuit who, in the Oklahoma case, wrote a concurring opinion where he laid out what he believes the Supreme Court's animus doctrine means. And he basically distilled it to two elements. The first is it's a novel exercise of government power. And that's one. And two is it's outside of that government's typical sphere of power. So here, you can't possibly say that those requirements are satisfied, because as that judge recognized in his opinion, these laws are as deeply rooted, this idea that marriage in the law is the union of a man and a woman is as deeply rooted as any law in American history. And as Windsor recognized, the states have the essential authority to define the marital relation and have always had that authority. So I think that's why the animus doctrine doesn't work, and I think that's why we really didn't hear much discussion about it yesterday. But the other point that I would highlight, which is one of my favorite points in the Sixth Circuit decision, and that is, even if the court were to agree with that animus doctrine, and even if it were to strike down these particular marriage amendments, the plaintiffs wouldn't get, or the petitioners wouldn't get what they're seeking, the ability to enter a same-sex marriage, because all it would do was the states would then default to their existing marriage laws before those laws. So they would have their common law definition of marriage, which is the union of a man and a woman. So in effect, the theory doesn't get them the relief they're seeking.
Maybe that would get rid of the suspenders, but the belt would still be there.
Does someone want to handle the sex discrimination question?
I'll take a stab at it. Essentially, I'll be repeating what John Birch said yesterday, because I think he got it right, and that is, when you look at Supreme Court precedent dealing with sex discrimination, you find a common theme in all of those cases. Men as a class are treated more favorably than women as a class, or vice versa. Here, we don't have that. It's not as if the states, for example, said that men can marry other men, but women can't marry other women. That's not true at all. The sexes are being treated the same. So I think that for the court to adopt the sex discrimination argument, it would be an unprecedented expansion of the Supreme Court's sex discrimination jurisprudence. One other point that oftentimes we use in oral arguments is our opponents come back in response and say, well, but in the Loving case, the court found that equal application of the law doesn't necessarily mean that there's no constitutional problem. In other words, there the argument was that the issue of race, that just because a particular person couldn't marry a person of the same race, of a different race, that didn't immunize the law from a racial discrimination attack. And so they try to analogize to that here. But again, that expansion of the law, we've never seen it in the sex discrimination context. So I think the attempt to rely on Loving is misplaced for that reason. It's also misplaced for another reason, which is the Supreme Court said at least twice in the Loving decision that those laws were motivated by racial animus. I mean, they said that the desire to promote white supremacy. They said it twice in the decision. And here, it's laughable to suggest that these laws were motivated by the desire to promote men over women or women over men. It's just simply not what's at issue here.
And going to Justice Kennedy's millennia argument, you don't have a millennia-long tradition of anti-miscegenation laws. You have this is a specific thing that happened. I'm sure there's other places that have had it, but it was very unique to the American South that was happening, and so it's not to this institution that we have of marriage always has actually that was part of the problem is the anti-miscegenation laws were actually limiting marriage in a way that the millennia-long tradition doesn't limit marriage because it's about an institution of man and a woman. It doesn't have anything to do with what race you are, et cetera.
Yep.
So with that, we're going to have to conclude. I'll just highlight, if you want to read more about this, go to the Daily Signal website. We've already posted some of our feedback there. We're going to have 2 posts from Gene Scher that'll go up later this afternoon and another post from myself reacting to the court's arguments yesterday. And please join me now in thanking our panel.